you this afternoon for those who are our side in Africa this afternoon for this this consultation, the Africa consultation on human rights compatible international investment agreements. My name is Sab Benjamin Traoré. I am the ACCA project coordinator. ACCA stands for the African Coalition for Corporate Accountability. And together with the co-organizers of this activity, which are SEATINI and the UNDP, I'm very delighted to welcome you for this very important, very critical discussion around a very heated topic. I would also like to mention that this meeting or this consultation has been convened by the UN Working Group on Transnational Corporations and Other Business Enterprises. The UN Working Group on Business and Human Rights, as we used to call it, is represented today at the highest level by Professor Suraya, who will be taking the floor in a few minutes to give us some background on the consultation and the whole concept of having this conversation. So on our side, we would like really to thank you for making time for this. We know that it will be a very long afternoon, but we are looking forward to your inputs and to your reflections on the issues that we are going to discuss. So just a brief idea of the agenda, although you may have already received it. So we, as you know, this consultation will be more of giving the opportunity to stakeholders to reflect and to give their opinions on specific issues around the compatibility of investment agreements with human rights and environmental norms. So the floor will be most of the time given to the participant. However, we thought that it would be interesting to have a few introductory reflections on each of the topics that we will be going through this afternoon. So we have four main topics for the discussions. The first one being the policy space and the realization of human rights obligations. The second one is international investment agreements as instrument for promoting investors' accountability. The third one will take us to discuss the issues around international investment agreement and the dispute settlement mechanisms, the existing dispute settlement mechanism, and how it can promote more access to a remedy for right holders. The last topic would be most of a wrap-up discussion on what we expect from the business and human rights, the working group on business and human rights, as they are preparing the report. So without further ado, I would just now give the floor to Professor Suraya. Please, and that would be for all the panelists, forgive me for not giving a very long introduction to each panelist. We have a prominent list of panelists today. All of them are very established professionals and academics, and I will not have time to introduce them in detail. So please accept that I just mentioned your current position and the most known one. So I would now give the floor to Professor Suraya, who is an associate professor at the Law School of the City University of Hong Kong, but most importantly for this meeting, he is the Vice Chair of the UN Working Group on Transnational Corporations and Other Business Enterprises. So Prof, please, you have the floor.
Thank you very much, Benjamin. At the outset, I would like to welcome all of you on behalf of all the organizers, and I would also like to thank ACCA, UNDP, and SEATINI for collaborating with the working group and in organizing this consultation for Africa. This is very much appreciated. Now, in these brief remarks, I would like to focus on two aspects. First, what this report is all about, the substance of it. And the second is the issues about logistics, the time frame, what we have done so far, and what you may expect in terms of the process in future. In terms of the substance, the key objective of this report is to unpack Principle 9 of the UN Guiding Principles on Business and Human Rights. As you may know, UN Guiding Principles has 3 pillars. And pillar 1 is the duty or the obligation of the states to protect against human rights abuses by businesses. And Principle 9 of the UN Guiding Principles in pillar 1 expressly talks about states preserving policy space when they are negotiating trade or investment agreements. Now, as in many other parts of the global south, many states in Africa would like to attract more and more investment, and they try to negotiate these investment agreements. Now, sometimes those investment agreements may attract investment, but it may also have consequences for the countries in terms of the environmental pollution or human rights abuses and so on and so forth. So this report will look at that how can we strike a balance that these investment agreements are compatible with international human rights obligations of these states. Although the starting point for this report will be Principle 9, it will touch upon all 3 pillars of the UN Guiding Principles. It will focus on what should states do, but it will also talk about the human rights responsibilities of investors. Because most of these agreements confer rights, not duties, on investors. And I think that creates an imbalance. So how do we address this imbalance and ensure that these investment agreements also impose certain responsibilities about respecting the human rights and the environment on the investors? And the third component, which is the third pillar of the UN Guiding Principles, is access to remedy. Because investors can seek remedies by taking these governments to arbitration. But what about the affected communities? If we have a development project and that has polluted a river or a lake, or we have a development project which has harmed the human rights or displaced indigenous people, can they seek remedy by using this investment agreement against the investor company? And in most of these cases, these investor companies are from outside Africa. So that is about the access to remedy elements. So this report will try to cover all these elements. The report will build on what we already have in terms of the recommendations made by UNCTAD or other civil society organizations and scholars. And it will try to make those recommendations both to governments, but also investors and companies. In terms of the process and timeline, I'll be presenting this report to the UN General Assembly in October this year, but I need to finish this report, the draft of it, by the end of June. So just over a month is left now. We have done several consultations, all virtual, in different parts of the world. And this is the Africa consultation taking place today. We have one more consultation for Asia Pacific left for next month. Otherwise, we have covered rest of the regions of the world. We also issued an open call for input. I don't know if anyone from Africa submitted that, But if you still want to submit anything in writing for this report, we still welcome that. And we will be happy to post your submission on the project website. So we will be hoping to gather some interesting insights from Africa, what you would like to see in this report in terms of the recommendations, what are the unique challenges that you see are arising in Africa in the context of striking a balance between achieving economic development, but at the same time, not at the cost of human rights and the environment. And of course, increasingly, climate change is becoming a major issue. We all have also created a Google group. So if anyone is interested to know more about this project, or you would like to share your work, you can definitely join that Google group as well. Otherwise, I think that is the timeline that I'm looking at this particular point of time. So I will be mostly in the listening mode, and I would listen carefully and make notes. But sometimes I may have a question as well. But otherwise, I look forward to listening to all the panelists as well as participants about their views that what this report should look like and what recommendations it should make. So thank you very much once again, all the co-organizers and all the participants for finding time to join this consultation. So with these remarks, I would like to pass the floor back to Benjamin. Thank you very much.
Thank you very much, Professor Soraya, for these introductory thoughts. I would like, before passing the floor to our next speaker, I would like just to mention a few things in terms of logistic. I should have done that before, actually. So the consultation this meeting is translated from French to English and vice versa. So you just have to find the right icon down your screen and click on the right channel, or the channel that you would like to listen. Yes, as Professor Soraya mentioned, this is a very important topic, but it's even more important for us in Africa regarding all the issues and the concerns that have been increasingly raised around the negative impact of business activities across the continent. And for us, especially in ACCA, we know how critical this issue is on the continent. So I really hope that we engage in meaningful discussions around the subtopics that we will be developing now. So I would now give the floor to the first speaker, who will give us some preliminary reflections on the first topic. And after intervention, we will just open the floor to the participant for them to ask two main questions that I will share on my screen at the right moment. So the first topic, as I announced, is on the policy space and the realization of human rights obligations. And as we said, Professor Sott said before, the human rights international investment agreements can constrain sometimes our states in terms of how they comply with the human rights obligations. So let's listen now from Dr. Rosalind Akombe, who is the Regional Governance and Peace Building Coordinator at the United Nations Development Program. So, Doctor, you have the floor, and thank you very much for having accepted our invitation to share your important thoughts with us.
So thank you very much, Benjamin, and thank you so much, Professor Siraya, for those opening remarks. Benjamin, it's really an honor for me to join you today and to be supporting this really important conversation, which we believe is really critical as we figure out how to ensure that even as African countries, appeal for investments, international investments, that those investments are human rights compatible. So we are very pleased to be co-organizing this event with the UN Working Group, with you, ACCA, and with SEATINI, and hopefully we'll be able to bring regional perspectives to this really important report that is being developed. No, you've asked me to speak about the policy space, and first really to say that what we see, generally speaking, in the last few years is a more constrained policy space for addressing issues of human rights in general. The same way we've seen, a very restrictive political space for other conversations that are important. So discussions really on issues of business and human rights, while there have been, inroads made, this space is a very constricted space. And obviously COVID-19 has not helped because that space for engaging on these things obviously gets limited while priorities are placed on addressing the health emergencies and the economic impact of the pandemic. But actually, what we have also seen from COVID-19 is that our systems have been put to test, which then requires that we really pay attention to discussions like this ones, because it's really the poorest and the most vulnerable that end up bearing the effects of whether there are investment decisions that are made or whether the human rights violations are related to that. As the professor said at the very beginning, developing economies find themselves really in a situation whereby they have to try and attract as many investments, international investments, as they can, and yet they don't have full control of the global supply chains. They don't have the full control of the arbitration that happens after that. So in that, in a scenario like this, obviously, governments are caught in terms of policy making. They are caught in this difficult situation whereby you have to balance between the human rights, the environmental protection, and also the need to be able to get in foreign direct investment, which obviously is a valuable source for financing and making inclusive recovery important. But even as countries think about that, even as they develop policies for inclusive recovery, human rights compliance has to be at the center of it. And so, in these eras, we've said where we've seen more investment-driven development, what we are seeing more and more in a lot of African countries are attempts to create special economic zones and creating shortcuts when negotiating international investment agreements. And so, what happens then is that human rights as the first things that are thrown out of the window, because you're trying to establish, you're trying to attract as many investors as you can, and you're trying to create shortcuts. And in most cases, what we see is that the space for negotiating international investment agreements that also include human rights is really a tough one. And yet, we know that we cannot achieve the Sustainable Development Goals. We cannot achieve the African Union's Agenda 2030 without looking at human rights, without looking at job creation, and without looking at gender equality and protection of the environment. But this should not at any, be at the cost of human rights. And we see that happening, whether it's environmental rights that are violated, or whether it's unfair tax breaks that you see from companies that shouldn't actually be benefiting from those tax breaks, which makes you question what is it that then the country is gaining if you're bringing in international investors and providing tax breaks that are for a long period of time? What are the, is that a fair agreement that we are seeing in those situations? And as I've said before, we really do have a constrained policy space then in a context like this one, for even a discussion to take place on human rights, which then has really an adverse impact on vulnerable communities. So I think that's why it's really important for constructive dialogue to continue, like what we are doing today, in order to see how we can design investment agreements that enable and attract foreign direct investment, but also they also look at the other side. They look at the sustainable development goals. They look at the promotion of human rights and really promote responsible business conduct. And we really hope that from these discussions today and the report that comes afterwards, we will be able to increase that policy space that is available for conversations around these issues. In the continent, what we are seeing, related as we get more and more international investments, you are seeing, high instances of human rights violations, especially from business-related activities. And that's why I think it's really important that we keep bringing to the attention of investors what we already have as the UN guiding principles. And, Professor alluded to them, which is really looking at developing policy commitment, implementing human rights due diligence processes in all layers of the supply chain, but also enabling or providing access to remedy, which is a point that Professor made very eloquently. And in our view, really, in order to implement the due diligence and access to remedy requirements, investors must really focus on looking at, on reaching out and getting the stakeholders involved. I think it's also very important for us to understand, to ensure that there is enough information that is provided throughout the value chain. That is from the investment managers, from the service providers, from the investees, so that we have expectations set and influence that is put out there. I think it's really important that states preserve their regulatory space, that even in the despair of wanting to have investments included, in their countries, that they allow enough space to be able to negotiate international investment agreements that balance the promotion of human rights, the welfare of their people, and the employment opportunities that brings. And I hear all the time examples given about the Nigeria-Morocco bilateral treaty, which I understand has also enumerated or picked up a lot of some of the models that SADC has, where there are very specific provisions made there regarding investor obligations. And this is really a departure from the traditional approach where you only have voluntary investor commitments. So I think it's really important that as we work with the various member states, the African member states, we bring into perspective agreements such as the Morocco-Nigeria treaty, bilateral treaty, and see whether there are models that can be built around that. So it's not a voluntary exercise. It's an obligation that investors have to protect human rights, especially environmental rights. As I conclude, I want to really challenge you today. I would like to challenge you today to question the responsibility of investors to respect all human rights and investigate the role of the international investment agreements in providing access to remedy to individuals and communities, especially in places where land is held by communities. This also includes going beyond just the community rights to looking at equal pay for women, to looking at respect for child labor laws, to looking at the sanitary conditions in which these companies that are investing end up putting the workers, for those of you who are familiar with some of the cases that are going on in Kenya, we have, one of the very eminent human rights organizations that has taken up the course to look at the human rights conditions of workers in Kakuzi farm, where they work for many hours and under very, very difficult conditions. We see that in the tea estates. You see that in the mining industries in DRC. I mean, these are things that I challenge you today as you have this conversation, to look at ways in which we can then put the responsibility back to investors to ensure that they respect all human rights. I also really hope that member states will adopt a more holistic approach towards international investment agreements and look at them beyond investment vehicles, but to also see them as tools to realize human development potential of investment, especially for those who need it most. As UNDP, what we are doing around the world is really helping countries and helping our member states in looking at some of these business and human rights policy instruments, and really facilitating and expanding, the processes so that you have a participatory decision-making process. We also have been putting a lot of focus on strengthening access to justice for victims of human rights and abuses, and really providing them advice on how to address them, but also working with the other side also in terms of working with companies and corporations on how to redress and address some of these risks that they pose, both environmental risks and also risks really to human rights. We've also obviously play a role as UNDP in ensuring that we provide a multi-stakeholder platform for engagement on both policy issues, but also on practical issues that happen at the country level. We're currently providing support to about 46 countries in sub-Saharan Africa. And we hope that, we will be able to hear from colleagues who are working in places like Sierra Leone, Ethiopia, and Zimbabwe on what is being done in terms of promotion, of access to justice. It would be great to hear from Zambia, Mozambique, Tanzania, Liberia, and Kenya on what is being done to advance business and human rights national agendas, because these are areas that we as UNDP are working on. And at the regional level, we really are hoping to continue the conversations we've started, the constructive dialogue between civil society, governments, and businesses. From our view, we really think that right holders should be at the core of what we do, and they are at the core of what we do as UNDP. And civil society, human rights defenders will continue to be a priority as we continue our efforts in Africa. I really hope that with all the participation we are seeing today here, that it will be an enriching experience. As Professor said, he'll be listening. We too from UNDP will be listening carefully to the views that you have, because we are coming together to develop what we are calling a governance and peace building framework for Africa, where business and human rights is going to feature very highly. So we hope to get views from you that can help us look at our programmatic interventions for the next 5 years as we do our strategic plan. I thank you again so much, Benjamin, and look forward to really constructive conversations. Thank you.
Thank you very much, Dr. Akombe, for these very brilliant remarks. And I do think that this is really helpful, as it paves the way for the discussion forwards today. Again, thank you for your availability, and we are very happy and lucky to have you here today. So, as I said before, we will move now to the discussion phase of under that topic. I will now share my screen. We have prepared 2 questions that can serve as a framework for the discussion, but please do not hesitate to raise issues or reflections that are not completely in line with these two questions. So I will now open the floor for that and give the opportunity to anyone who wants to comment on these two questions and something that is related to the topic to take the floor. So in terms of procedure, it would be great if anyone who is taking the floor can just introduce themselves and say for which organizations in which capacities they are with us today, and make their comments. I just forget that I spoke early on about interpretation. I didn't say it in French. Je voudrais juste informer les uns et les autres que cette conversation est interprétée. Je suis désolé de ne l'avoir pas mentionné au tout début de la réunion. Je m'en excuse. En tout cas, il y a eu...
I would like to indicate that interpretation in English and in French is available. So for the Francophone or French-speaking participants, you can use the tab at the bottom of your screen and select the channel that is more convenient to you.
I will read them out and allow anyone to take the floor. So under this topic, we have prepared these two questions. The first one is, in what way do the substantive and procedural protections enshrined in existing international investment agreements undermine the state's duty to protect against human rights abuses by third parties? Have changes in recent treaty drafting practice done enough to protect policy space and flexibility? That's the first question. The second one is, how can future international investment agreements play a role in strengthening rather than undermining the capacity of domestic institutions to realize human rights? What reforms are necessary to achieve this? I think for the sake of time, I would be tempted to think that we can make comments on any of these issues. And as I said, we won't take it one after one, otherwise it will be probably too long. I'm just recalling that we have the next 30 or 40 minutes to discuss that topic. So now I open the floor, and please just raise your hand or just yes, take the floor directly, and I will let you speak. Anyone wants to start? Mutuso, are you asking for the floor?
Well, thank you very much, Benjamin, for that. Well, I'm interested in terms of to comment on question 2, how future international investment agreements play a role in strengthening rather than. And my biggest concern is when it comes to those.
Can you just please introduce yourself and your organization? I know you very well, but that may not be the case for everyone.
Okay, thank you very much, Benjamin. My name is Mtuso Liwayo. I'm the director of the Zimbabwe Environmental Law Association. We are based in Harare, Zimbabwe, and we have a program on business and human rights or responsible investments. And we have been involved in terms of implementing the UN guiding principles on business and human rights. And we are also a member of the African Coalition on Corporate Accountability. And my interest there is basically on question 2, which says, how can future international investment agreements play a role in strengthening rather than undermining the capacity of domestic institutions to realize human rights? And my interest focuses on stabilization agreements and their potential to undermine the realization of human rights by domestic institutions. I've done some review on some of these stabilization agreements, and I think they're actually a big problem. I think I understand the rationale which resulted in them being developed, but I think there's now time to now really have a review in terms of whether they are helping or they are basically undermining the realization of human rights. Because to a large extent, our ability as developing countries to derive benefits from the exploitation of resources that are found within our countries depends on these agreements that we negotiate. And at times, the putting in of these stabilization clauses or agreements actually undermine the realization of these human rights in terms of what they entail when there are those developments which the investors may feel are not favorable. And at times, we have seen that when it is to the advantage of the investor, these are not a problem, but it becomes a problem when these are to the benefit of the host country. So for me, I think we may need to really look into those in terms of how we focus on stabilization agreements or clauses in the future so that they don't undermine domestic institutions in the realization of human rights. Thank you, Benjamin.
Thank you very much, Mutuso. Thank you. That these are very insightful reflections, and I can see that Prof has raised his hand. So please go ahead.
Thank you. Thank you for this intervention. I had a question for Mutuso, and the question is, can he provide any concrete example from Africa how stabilization clauses have undermined human rights or the protection of environment? Because he has done some analysis. So, or if he can share this via email later on, that will also be helpful. Thank you very much.
Thank you very much. Thank you. I don't know if Mutuso wants to come in very quickly. Otherwise, it's also an open question, and if you prefer to send the examples that you have found to Professor also directly, that's fine. But since I can't see any other end, I can give you the floor again, Mutuso.
Sure, I'll be happy to share those. So my concern is how they limit the fiscal space and some of the revenues that can actually be generated, that can accrue to the state or the government, that it can use now in terms of realization of human rights. It could be environmental rights, it could be economic rights, it could be social and cultural rights. So for me, that's where the concern arises to say it does limit that ability to regulate. And in the process, the host state may end up losing that it can use in terms of fulfilling the realization of human rights. So I'll be happy to share concrete examples, and I'll share those through email. Thanks, Benjamin.
Thank you very much, Mutuso. Thanks. Does anyone else want to come in? Please feel free to take the floor and to make your comments. This is really an open and very free space. And yes, it's a conversation, and I would like to hear more from participants. So does anyone?
Yes, Benjamin.
Yes, oh, my friend from Sierra Leone.
Sierra Leone, yes.
Yeah, please, you have the floor.
Thank you very much.
Abu, please,
yes,
go ahead.
I'm Abu Brahima. I'm the Executive Director of the Network Movement for Justice and Development, and work in Sierra Leone. We have been working around the natural resource sector for over 20 years now, and we are quite familiar with some of the intricacies of investment agreements and also the government's commitment to international human rights provisions and standards. In Sierra Leone, I mean, Sierra Leone is a small country with a lot of, past historic conflict, reading scars all over the place. And over the years, there has been a lot of attempts to bring Sierra Leone into the global, framework so that Sierra Leone becomes also compliant with international standards, with, attracting all kinds of, people for investment and for business and for development. And I think that Sierra Leone has signed up to many international, human rights, instruments, both, regionally, sub-regionally, and also globally. And we have also Class A international, Class A Human Rights Commission in our country. And we are really quite on the top in terms of, but what has happened over the period is that the state seems to be so fragmented and so compartmentalized that institutions and ministries or agencies don't talk to each other. And they are in their own private zones. So when businesses are being sought, investment in the agriculture sector, in the mining sector, in the fisheries sector, in the forestry sector, these businesses are seen to be completely separate and too economistic, and the interest is how much money is the country going to derive from it. Now, when these investment agreements are being designed, no reference is made, for instance, to the human rights, provisions or standards that we have signed up to. Even when the Human Rights Commission, we work with the Human Rights Commission to develop the Business and Human Rights National Action Plan, no reference is made to that. No reference is made to the African, provisions in the African Charter and Human and People's Rights. No reference is made to international covenants like, the right to children or the right to women and so on, or the economic, social, and cultural rights. So it's like a solo engagement when these businesses come. So when these agreements are being framed, they are framed in their own right, skewed towards business promotion and protection. And this is where everything is missed. Because when these agreements don't speak to other national institutions and instruments, you do not see how they can be complemented. You don't see how they can be used to protect and prevent violations and abuses. And that's why we experience all the time in a police brutality, because businesses need protection and they use our state police institutions to even brutalize our own people. Environment is decimated because the environmental provision in the human rights is not taken on account of. So they create mini oceans and mini mountains all over the place, and people are displaced and completely relocated, without any proper framework for even how they are to be compensated or to be resettled. So they don't speak. Instruments and state organs and institutions don't speak to each other. Unfortunately, we do not also employ the services of the international UN agencies to come in and be part of the process of supporting or aiding government to help in framing these institutions and these instruments. And I think that there is the responsibility of both locally, nationally, when the governments are under pressure because they need money, they are poor, they need money to do their national investment and development. But at the same time, the international community leaves countries on their own. And knowing very well, when crisis comes, they send in troops to come and assist. But what gives rise to those troops when crisis is there and is booming, and these investment agreements are the roots to some of these crises? Because when people become too poor and too marginalized and too exploited and over abused, then they rise up and then they resist. And so there is real responsibility on the part of the state, but also on the part of the international community. And also the communities, the level of vulnerability is too high that they cannot resist on their own. So I think that and these investment agreements are not also looked at from the conflict point of view. And they need to be conflict sensitive, because human rights and conflict are, two sides of the coin. And if they are human rights oriented, but also not conflict sensitive, then there is something missing. So I think that for us in Sierra Leone, this is really the problem. Our countries are moving towards phases that are very delicate, but there is disconnect along the line. So how can UN system really help our government to create these connections among agencies, among government institutions, and then therefore the investment agreements to be able to reflect some of these instruments that we have developed both locally and globally or continentally. I think this is how we could perhaps make some headway. Thank you.
Thanks a lot, Abu Bruma. Thank you for these very insightful comments, and this is very profound. And yes, thank you again. Is there anyone else who wants to come in? I can see here an hand, but I don't know what's the name. It's just A. What I can see here, it's A.
It's maybe Benjamin Arnold.
Arnold. Okay. Thank you, Arnold. Yeah.
Sorry about that. Yes. Thanks again, Benjamin and the team for organizing this. My name is Arnold Kwesiga. I hope everybody can hear me.
Yes, yes, go ahead. It's fine. Yeah.
All right, yeah, from the Center for Human Rights. And my question or even submission follows what Abu has been talking about. One of the things that we've continuously dealt with when it comes to international investment agreements is that, and has always been said, you do not always get the best agreement, you get the agreement you negotiate for. And most of these states find themselves constrained technically, especially around this. One of the biggest challenges I see, and I would like to be guided by the working group and Professor Sreya, it seems that a lot of our international investment agreements are anchored within contractual law rather than human rights law. And so many times we have situations where what is negotiated, it's from a contractual perspective, it's what do we gain and what are you offering for this to happen? And so, and echoing what Abu has just said is that there is very little reflection or even reference to international human rights framework and standards, which affects the nature of agreements that you end up having. And like I noted in the beginning, the constraint seems to be on the weaker states or the states that do not have technical expertise around these negotiations. And so many times they are shortchanged and get agreements that tend to benefit multilateral investors or most of these states at the expense of developing countries. So how do we, and my question is, how do we then ensure that a lot of these conversations or negotiations within international investment agreements are anchored within international human rights law standards and framework, but also re-echo the premise of human rights over investment agreements, which tends to be suffering at the moment. Thank you.
Thank you very much, Arnold, for your comment and also your questions that are in a way comments as well. Yes, this is, I don't know if Prof wants to come in, but since we are taking notes, they are listening, probably we'll give the opportunity to someone else to comment. I could see Emmanuel, Emmanuel Ose.
Yes,
yes.
Yes, thank you, Benjamin. My name is Emmanuel Ose, and I'm also a student of TILA. But prior to the program, I worked with the Ghana Investment Promotion Center, and I've engaged myself with a lot of these agreements, negotiation, and other things. So one thing you realize is that, one, let me take it from in terms of the capacity and the people who are engaged in these negotiations. You realize that most of the times we take everything hook, line, and sinker from the models that are handed over to us by the capital exporting countries. And you realize that they are looking at their interests. They are not looking, the whole investment arrangement is supposed to be a win-win situation. Whereas they are interested in their profits, where they are interested in their resources, we must also be interested in the human rights aspect. We must also be interested in the environmental rights aspect. And we must also be interested in things that are bothering us. However, you realize that most of these investment agreements do not re-echo what we want as an Africans or as a capital or investment importing countries. Then secondly, you look at the architecture, you realize that most of these institutions are playing dual roles. They are playing a regulatory function and a promotion function at the same time. So when these models comes in, he's looking at, okay, what will best sell this country for us? What instrument can best sell this country for in terms of the investment promotion aspect? At the neglect of the human rights, environmental rights that are also key to us. So I think that we must be able to give a regulatory space, as the first speaker said, and we should be able to build the capacity of the negotiators so that they should look at things from a holistic point of view, not from just the promotional point of view. And if we are able to do that, at the end of the day, we will get the best of agreement for ourselves, not the ones that will benefit only the capital exporting countries. Thank you.
Thank you very much, Emmanuel. And sorry, I did not recognize you at first. And by the way, thank you to all the TLE students that have joined this consultation. And really, Emmanuel, thanks for sharing your experience on this. This is very helpful. And thanks to all of those who have spoken so far, raising issues, but also making suggestions for what can be done better. That's exactly why we put these two questions. Now I will just give the floor to, if I can see a few other hands raised. So we are a bit constrained by time, and as the discussion goes, I know that we will have more discussion on some specific issues. So please look at the agenda, and if you have any comment that can be reserved for a next step, please, we can do that. So I am seeing here Bamba from Guinea. Mon cher ami Bamba, merci beaucoup de nous rejoindre. Je te laisse la parole.
Dear Bamba, thank you for joining the floor. I'll give you the floor. Good day for everyone. Thank you very much, Benjamin, for this opportunity which has been given to the different partners in organizing this consultation. For us as a civil society organizations, I would like to add my comment as the previous speaker on the second part when it comes to the reforms which should be taken into account or which should be established to allow the protection and the respect of human rights in the different negotiations of international agreements. Before going to the reforms, I think we need to note or to identify the context where these agreements are signed between the states and the foreign investors. The context is very important to underline. Mostly it is characterized by the fragile jurisdictions or legal framework, national framework, which is already a difficult challenge, which is undermining the respect of human rights. We need also to note that most of the investments oriented to our countries, I'm especially speaking about Guinea and in the framework of the different activities, most of the investors are coming from emerging countries. These countries, we do not really know the standards when it comes to the respect of human rights. And this is a challenge when it comes even to their activities in their own countries or investments. The second point is the different states, our states are in competition to attract foreign direct investments. So it means that we are undermining our legal framework to attract the foreign investors without taking note of the international or the continental dimension. So when it comes to the reforms, we need to think first to include the transparency. When we take the example of the agreement between China and Guinea, 20-year agreement about 20 billion of USD for the building one infrastructure, despite the fight of the civil society for not having this agreement, but this agreement has not been signed. So how can we see the accountability without knowing the main points or neglecting the main points. I'll come back again. Thank you for this opportunity which has been given to me. Thank you very much, Bamba. This is very important what you have underlined. And I think that this is part of the heart, it's at the heart of the different notes that we do have. And we'll have also another opportunity to listen to you.
Okay, thank you so much, Benjamin. I just want to add just a bit. My name is Josephine Chiname, and I'm with the Zimbabwe Environmental Law Association. So to add on to the discussions that have been ongoing, I just want to respond. I think it is the second part of the first question on have changes in recent treaty drafting practice done enough to protect policy space and flexibility? I think in response to this, maybe not necessarily looking at treaty drafting practice, but the recent trend of different countries legislating domestic pieces of legislation that regulate investment has shown that countries in Southern Africa, countries in Africa are now becoming aware of the need to provide enough and flexible policy space for them to be able to regulate human rights violations in the context of investments, especially when you are looking at the environment. For instance, Zimbabwe in 2019 promulgated the Zimbabwe Investment and Development Agency Act, which clearly provides that investors have obligations to respect every other legislation in Zimbabwe, including the constitution, as well as to preserve the environment. So I think this is a trend in which enough regulatory space and enough flexibility is being offered. But however, I think it also goes down to what the previous speaker and Arnold also mentioned, that we might have these clauses, these laws that allows for the respect of human rights. I understand so many African countries has constitutions that actually place obligations even on corporate actors to respect human rights. But now the question is on the institutional capacity of our countries. Do our institutions have the relevant capacity to monitor and implement human rights obligations in the context of investors, given the capital and the power that investors seem to wield in our countries? Thank you, Benjamin. That's my contribution to the discussions.
to focus on the topic 2, how to make or how to use international investment agreement to promote investor accountability. And there are very interesting questions, and I will briefly address some of them, and I think we'll have the opportunity to discuss the other questions during the discussion. So the very issue of investor accountability is a recent one, because and I think it was Soraya who mentioned that at the beginning, at the very inception of the regime, the idea was to promote and protect investment. And you will see that the majority of what we call the old generation of investment agreement are entitled Agreement for the Promotion and the Protection of Investment. And only states were supposed to be obligations. And for the investor, it was only rights, not duties. And this is also what we saw with some investment decisions, where some tribunals say that investment agreement impose no obligation on investors, only on contracting states. But recently, we have witnessed a kind of shift, because some tribunals now are saying that it can no longer be admitted that investors operating internationally are immune from bearing a kind of or be subject of international law. But between such a statement and the implementation of this principle, there is a kind of gap. And this is where now we come with this idea of how now to use international investment agreement to promote investor accountability. Maybe we need also to keep in mind that, and I did it yesterday before, I just tried to check how many investment agreements contain the word or the expression human rights. One of the very comprehensive database is the International Investment Agreement Navigator. And I found that around 12% of investment agreements include the expression human rights. And also this idea of having direct obligation on the conduct of foreign investors is a recent trend, and it has not gained a kind of real recognition and international treaty practice. However, now we have what we call the new generation of investment agreement. And a good number of them were signed by African countries, be it at the bilateral level. I think Soraya and the previous speaker talked about the Morocco-Nigeria bilateral investment treaty. We have also those agreements at the regional level, the SADC protocol, the ECOWAS Supplementary Act, the COMESA, and even at the continental level with the Pan-African Investment Code. All those agreements contain some elements that can be used as channel for the promotion of investor accountability. And to go straight to some of them, we need also to keep in mind that this is a very interesting development. Some of those agreements have a specific chapter for investor obligations. Imagine so, and this is what we can see in the ECOWAS Supplementary Act on Investment, and also with the Pan-African Investment Code. And those obligations are what we call general obligations, corporate governance, pre-establishment obligations. That is the obligation to conduct environmental and social impact assessment. We have also anti-corruption, corporate social responsibility, and interestingly also investor liability. That in some of those agreements, we have a provision dealing with human rights obligation. And I put here the ECOWAS, the Article 14, Alinea 2 of the ECOWAS Supplementary Act on Investment, according to which investors shall uphold human rights in the workplace and the community in which they are located. And there are a number of actions that need to be taken or avoided. So this can be directly I mean, we can also find the same provision in the Pan-African Investment Code and also in the Morocco-Nigeria Bilateral Investment Treaty. However, such a provision is still a bit vague because the exact content, what does it concretely mean for an investor to uphold human rights? And also there are some questions I'm trying to raise here. Is the mere reference to codes such as the ILO Declaration of Fundamental Principles on Rights enough? And what happens in case of non-compliance? So based on those kind of questions, I would say that the signal, I think this is one of the questions mentioned in the invitation. What we are seeing right now, at least we have now a signal, but it's a soft signal because most of those agreements are not binding agreements. No? And for example, the ECOWAS Supplementary Act on Investment is still limited to intra-ECOWAS agreement. So this means that the scope is still limited. So this is what I can describe as a soft signal to investors. But let me maybe add a few words on who should be able to initiate claims against investor. And I think here the right to initiate claims is a very interesting one because right now we are having those reform process at the multilateral level. And we can see that some countries are now pushing maybe for not only investors, but also other affected individuals and communities to have the right to initiate claims. This is what we can see on the submission from the government of South Africa, but also on the report of the UNCITRAL Working Group 3. And as I put it at the end, granting, it's true that this is still being discussed, but granting such a right to other affected communities and individuals is not without challenges, because in general, this investment arbitration is around it's between 3 to 5 years. It is very costly. So how can we ensure that those individuals and community will be represented? Who will fund for them? Those are the kind of questions. And when it comes also to the issue of jurisdiction, we can see that in some of those recent agreements concluded by African countries, a very interesting development is now the jurisdiction of the home states over acts and decisions made in relation to the investment in the host states. For me, this is a kind of double-edged sword. Why? Because, and this is something, a very recent development, for example, at the beginning of the year, Shell, the Court of Appeal in the Netherlands found that Shell was responsible for some of the acts of his foreign subsidiary in Nigeria. But 10 days after that, we saw that a Nixit case was filed against Nigeria. So even if this is a very interesting development, maybe we need now to clarify the kind of link, the kind of impact this jurisdiction can have on investment arbitration. And I hope I think I will limit myself here since it's a discussion. Probably I will try to add some input during the discussion. So thank you, Benjamin, again, and I'm ready now to listen to the other participants.
Thank you so much. Thank you so much, Dr. Kabri, for this very brilliant setting up of the framework for the discussion on this on this second topic. This is very, very interesting, very helpful. You went into more technical aspect of the subject, which is welcome. And now, yes, I forgot to introduce Jonathan at the beginning very well. sometimes when we are familiar with people, we take the introduction a bit lightly. I'm sorry about that. Jonathan is the manager for the Trade and Investment Master in at the University of Pretoria. And thank you very much again, Jonathan. Now I will share again the agenda so that we can see the questions under that particular topic. So I will read them out again and open the discussion. So in what ways do international investment agreements and international dispute settlement mechanism undermine?
I think these are not the right questions, Benjamin.
Sorry, sorry. Yes, thank you very much, Prof, for being very watchful. So should international investment agreements provide legal or other procedural mechanism to hold investors accountable for violating laws or contributing to human rights abuses? If so, to what extent? Who should be able to initiate claims against investors, and who should make determinations regarding investors' misconduct? Second question, what signals, do international investment agreements send to investors regarding responsible business conduct and investors' accountability? What signals should they send? Last question under this topic, what are the human rights responsibilities of other users of international investment agreements, including law firms and third-party founders? So these are the questions, and again, you can go even beyond these questions and make comments that will be useful under this topic. So I'm opening the floor now. Please feel free to just come in and make your comment. I can't see any hand here. Just waiting. Okay, I can see 2 hands. So I will start by Abu. Please, Abu, you have the floor.
Thank you very much. And thank you, to the presenter for, opening up the issues and clearly, indicating that there are some provisions in some, some instruments where investors are expected to be held accountable. And I'm happy that you mentioned the ECOWAS, instruments. And actually, in the 2019 ECOWAS Modern Minerals Development Act is quite strong on the issues of investors being responsible and being held accountable for various forms of abuses, issues that have to do with environment, issues that have to do with children, issues that have to do with women, and the abuse of women and their rights, communities. So it's a wide range of provisions in that Model Act. Unfortunately, again, the states within ECOWAS are asked to implement that agreement, that act, and to make it part of their own laws. That is not an easy thing, because now the states are left on their own to do what they think is good, expecting that, the goodwill is there and so on. But that's not easy, because the states are coming headlong face-to-face with their donor countries, not the companies, because companies are, I think that the companies are agents. You know, the real people, the real institutions, or what you call the culprits of abuses, are the states, that the home countries of these businesses. These are the ones, and I think that perhaps I could say that there is real complicity in this process, where the states are promoting, you know, like Europe, all of Europe and so on, US, they're talking about human rights and they have all these laws, and yet their agents, which are the businesses and the enterprises, they come into our countries and misbehave. And then when they misbehave, our courts are weak. They're not able to take them on, even when the communities bring lawsuits against them. They are sent to arbitration, you know, courts in Europe, in America, and these courts are created by these states to protect their companies. So what are we talking about? I think that there is really, you know, complicity to just ship all our resources out, good things that come to our countries. And I think we need to be aware of this. So the global context is very important, that we need to look at it. Human rights, the human rights institutions, the UN systems, the states institutions themselves, which I did not see the professor talked about, and we talk about other parties, banking systems and law firms. What about the countries, states themselves, whose, you know, where they have these industries, and these industries are fed by our raw materials. And so those states too should be part of the bargain, part of the third party that are really responsible, and they should be held accountable. And the last point that I want to raise is the fact that, you know, the fact that Africa put together is still not very strong in terms of putting institutions and instruments in place to try foreign companies in our continent for abuses and for misbehavior. It's quite, these arbitration institutions are almost outside. Most of them are outside of our continent, far away. It costs so much. Very recently, Sierra Leone was charged for suspending one of the mining companies in Lonsa, the iron ore mining companies, and the case was going on for several months now. And Sierra Leone, they had to, some big countries had to force our state, our president and the ministers to come and negotiate. And they say win-win, but it's not really win-win, because the terms are so ridiculous, they are so poor, that Sierra Leone is going to be losing anyway, whatever it is. And the idea was that Sierra Leone might lose the case. Well, you know, because the case is not tried here. We don't even know the dynamics that are around. So it really is, there's unequal power relations and unbalanced power relations that is really underlying all of these factors that needs to be looked at. So unless there is some power relations that is reorganized at the global level to create that balance, we will remain to be crying foul. And will remain to be really fighting. And I think that we'll be blaming ourselves for all the problems. There has to be some global, some commitment at some level that can bring the transformation that is required. I think a revolutionary approach might be the best way. Radical engagement that will change the dynamics and the focus. Otherwise, we'll be wasting our time talking about it. The UN system will have all our documents and all our proposals, and we'll go and sit on it, and the US will do what they want. Europe will do what they want anyway. Their companies will continue to flow into our countries and continue to siphon our resources, and they will go scot-free, and our people will continue to die and so on. So I think somehow there's some lip service that is playing that is not fair for Africa, for our countries, for our people.
Thank you so much, Abu, for your comments and also your concerns and frustration around this. You have touched upon very key issues here, especially the global power dynamics So that's very understandable, and we are here to discuss and to make suggestions, to make comments and recommendations. And I think everyone in his capacity would take on and move forward as it can. I have seen a comment here in the chat box. I can see hands. I will come back to you. A very interesting comment made in a form of a question. We don't need to answer it. I think I just want to put it in the discussions. Why is African-based arbitration tribunals enabled to attract cases related to investment disputes happening in African soil? Instead of discussing about regional dispute settlements and regimes, why we don't have continental level regimes except the AFCA, the AFTA. So this is interesting. It's I bring it into the discussions, and I will now give the floor to Joyce Mbaluto.
Thank you so much, Dr. Traore. Good afternoon, everyone. My name is Joyce Baloto. I'm a student at the Center for Human Rights. I happen to be very interested in this topic to the extent that I am writing my thesis on this. And I just wanted to give my comments based on the presentation that Dr. Kabre made. And he noted that, yes, there has been progress in terms of, having human rights obligations in bilateral investment treaties. But I wanted to give an example of my own country, which is Kenya. And I'm going to use an example of the Kenya-Japan Bilateral Investment Treaty 2016, which is one of the latest treaties in force. I understand there's a Kenya-Singapore BIT, but it is not really publicly available. I'm not sure why. In that BIT, you find that there is no mention of human rights in the entire bilateral investment treaty, and at the same time, they use a lot of quotative language seeming to encourage investors, encouraging the state not to relax health and safety provisions so to attract investments. And so this means that there's still a gap in terms of these new generation bilateral investment agreements, because this should be one of the new generation investment agreements. But as we can see, there's no really tangible human rights obligations that foreign investors can be held directly accountable in terms of a state instituting a claim against a foreign investor, perhaps on behalf of communities. And another issue I wanted to raise is looking beyond even bilateral investment treaties to investor state contracts and investment chapters in wider trade and investment agreements, such as the Kenya-UK EPA Economic Partnership Agreement that was signed in 2020. Looking beyond that, when you look at investor state contracts, they're very contractual in nature. In that context, how can foreign investors be held accountable? And I wanted to use an example of the Baku Tbilisi Kayan Pipeline Company that had to enter into a human rights undertaking. And my question is, why isn't this being used? Why is it not more commonly used? Because under that human rights undertaking, it's specifically provided that the foreign investor had human rights obligations, even outside that investor state contract. And I think that's one of a good practice that we can learn from, in terms of having foreign investors entering into human rights undertakings where they commit themselves to specific obligations. And then lastly, I wanted to say that what is the place of alternative dispute resolution as an alternative to the investor state dispute settlement mechanism that I would say is quite deficient in terms of, communities being able to access that kind of mechanism. Yes, there has been progress in terms of third-party submissions and a few amicus curiae submissions, but is that enough? Why can't we look at it from the context of preventing disputes by more inclusive public participation of communities throughout the process of investment from the point at which there are negotiations until the investment is realized, and even after that. So so basically, I'm trying to say that alternative dispute resolution is another very viable access to remedy mechanism that has not really been taken seriously in terms of public participation of communities in that sense, from the point at which the negotiations are happening. And for instance, in Kenya, with the Kenya-UK EPA, you find that it was challenged by communities because they did not really participate in the process of, this economic partnership agreement coming into force. And in as much as they went to court to challenge it, it is still in force. So basically, I'd like to say that public participation of communities is very important from the point at which there are negotiations to the point of, as an alternative dispute resolution mechanism, as an alternative to the ISDS mechanism. So thank you very much.
Thank you very much, Joyce, for sharing with us these details and info from Kenya. Yeah, your 3 points are very valid, and I think one of the things that you mentioned that I find very important is how, in the midst of this narrative, the new narrative around the new generations of bilateral investment treaties, we should still be very vigilant and look exactly at what is the actual language of the new bilateral investment treaties that our countries are signing up. So very, very interesting. Thank you very much. I will now give the floor to SEATINI.
Thank you, Benjamin and colleagues, for the submissions. It's Rogers from SEATINI. To me, the issues to do with these injustices that we are talking about are a ghost that is hurting us because of our liberalization policy that we accepted to take on. We see that states lost their control, even their powers were reduced when it comes to holding investors accountable for the injustices that they cause on the human beings. One thing we need to acknowledge is that African countries are very thirsty when it comes to attracting foreign direct investment, and they are also eager to attract, to increase on their resource envelope in terms of revenues collected and the sustainable development that they want to achieve. That's why they are doing, they don't want anything that will take away the investors from investing in Uganda, but they undermine the issue of human rights abuses that are being caused by the investments that they are calling for. The other thing is, I think one way we can reduce on the injustices is if we can sit down as African countries and we review our investment code acts to see that issues concerning human rights clauses and the environment are included in the investment code, so that the citizens they can have a document that can support them when such injustices occur. And then the other issue is we can also think of reviewing our BITs with countries to see that human rights issues are forefronted, to see that such things are solved. Thank you.
Thank you very much, Rogers. Thanks a lot. Jack Orike.
Thank you, Doc. Thank you for the opportunity. Just reacting to sorry, I'm Okore Jack. I'm a student as well at the TILA program in the University of Pretoria. And this is a live issue that we've been having discussions on. So from the reflections from Dr. Cabre, he talked about the soft signals that we've seen. And my interest is on the Pan-African Investment Code, which he alluded to. And previous interventions talked to the point that we've seen competition in African countries in trying to attract foreign direct investments. And we've even cheapened the standards of protection of human rights in order to beat other countries. And so I look at the Pan-African Investment Code. The speaker talked about a soft signal. I'm looking at the investment code, and if African states would have accepted to have this as actually a binding thing, it would have created uniformity so that we have a minimal standard for African states in terms of protection of human rights, because it has a whole provision on protection of human rights, although it is not very, very detailed. You also look at the code, it talks about cultural rights. And now that speaks to the question of local communities that we've been talking about. And I will want to talk about the issue of locus standi. So we know that these investment treaties, most of them are contractual in nature. And since they are contractual in nature, then what space are we having for local communities who are not part of the contracts between state A and state B, who are the proper parties and the investor in this whole conundrum of investment? So whereas it is good to think about having locus standi so that we have local communities having direct access to arbitration facilities so that they can talk about their violations, because we had interventions to the effect that there is a political drive to investment, and most of the time states are not ready to take up these issues that are affecting local communities under the fear of chasing away investors. So we need to have locus standi, yes, but how then do we fit it into our investment agreements so that we see the place of local communities and cultural rights, issues to do with land for these people, which are the very rights that we've been seeing being violated. So a solution is to have locus standi for them in these new generation agreements, and to have support from civil societies, and international organizations in bringing awareness to local communities and in helping them to actually realize their rights when such violations take place. Thank you.
Thank you very much, Jack. That's very helpful. Good contribution to our conversation. We still have about 10 minutes to go under this topic. And then the initial plan was to take a break, but yes, we will see how we can manage probably to reduce the break time so that we can go straight to the two last point. But before arriving at that level, let's just hear from three other persons here. I can see Nelson.
Good afternoon, Dr. Traore. Thank you very much for the opportunity. Merci beaucoup. I would just want to talk about, in the context of, how dispute resolution can be used to protect or, enforce human rights violation in investment in Africa. I think yes, the international system of investor-state dispute resolution has failed us in this regard. Yes, it has. But have we also introspected to look at the framework for protection of these rights and enforcement of these rights domestically? Because definitely you see that in some BIT models and investment agreements, right? There is always the need to engage domestic remedies first before moving on to the international scene. So domestically, in African countries, do we have the proper legal framework? Do we have judicial availability of remedies for persons whose rights have been affected by these investment activities? And I would use my country, Nigeria, as a focal point for this discussion of my contribution. Just as Dr. Kare had rightly pointed out, it has been a very big concern for communities, particularly in the Niger Delta area of Nigeria, wherein oil exploration and production investment activities are being carried out, to find and to get justice for environmental degradation and human rights violations done by most of these foreign companies carrying on oil exploration and production activities in the Niger Delta. It has been difficult getting domestic remedies, getting domestic justice for it. So you see them leaving Nigeria to go to the UK or go to other countries where these foreign countries, these foreign companies are registered to seek justice. And it bothers me because when you look at the fact that even in most African countries, Nigeria too, and I think in Botswana, most of our constitutions are forged in such a way that socioeconomic rights are not enforceable. And we always try to fragment socioeconomic rights from human rights. You see, for instance, in the Nigerian Constitution, in Chapter 2 of the Nigerian Constitution, wherein environmental rights are guaranteed or protected, the Constitution also provides that those rights are not justiciable. That is to say, those rights cannot be enforced in court. So you see people, or you see frameworks or domestic frameworks wherein human rights, environmental rights, political rights, social rights have been fragmented, and then one is enforced and the other isn't. And you see that this has cost lots of victims of human rights violations, environmental rights violations, from getting justice domestically. So I think it's very, very important that African countries introspect, look inwards and find, first of all, the way or balance to get or make sure that there is a platform or there is a system set down to ensure that human rights victims or victims of human rights violations from investment activities receive adequate justice domestically, whilst also tackling the problem of investors, human rights protection in investor-state dispute resolution internationally. These are my thoughts.
Thank you very much, Nelson, for pointing out that for you, the avenue that we should privilege the most is the domestic judicial remedies. So thank you a lot, Nelson. I will give the floor now to Cesar. Cesar, please.
Thank you.
Yeah.
Thank you, Dr. Benjamin. Good afternoon.
Yeah.
My name is Cesar. I am still a student, and I'm from Mozambique. So I would like to speak looking at my country. So in Mozambique, the Mozambique Bar Association and some local NGOs used to represent the local communities filing cases before the administrative and the judicial courts regarding the violations of human rights and environment caused by those investors and companies. However, the main concern is to enforce some decisions before international level, because as you know, the investors and states depart to resolve investment disputes before the international system. And the intervention of local communities as dispute part is very limited. I think now it's time to think, to review the rules and create condition to permit the local communities participate at international level as a dispute part, because they are the one who suffer a lot with cases of violation of human rights and environment caused by these investors companies when they are operating in the country. Thank you.
Thank you very much, Cesar. Thank you. You are highlighting the role of local communities as they should be, according to you, participating more in the dispute settlement mechanisms, especially at the international level. Thank you. Bamba, je vois que tu as la main levée.
I can see that you have raised your hand, so let me give you the floor. Thank you very much, Dr. Benjamin. I forgot to present myself. I'm Bamba. I'm working for a Guinean NGO for the protection of human rights of the civil of the citizens. So I would like to answer to the first question. So should we have mechanisms so that we can impose implications on the order? It's very important. Someone has mentioned that our national legal systems should have their say. So most of the international treaties, they do have different provisions against the respect of human rights. So it's the most favorite nation, protecting the interests of the investors. So this gives the opportunity for the investors to resort to these mechanisms that will allow them to not submit themselves under the legal or national jurisdictions. So we need to strike a balance, and this balance should help to counter this consequence. We need to strengthen the local systems, which means the communities and the legal system of the nation. So we need to strengthen our legal national systems. We need also to revise and to rethink the different treaties and the different regional policies in regard to the regional integration. We need to look at the notion of human rights, and we need to set up different mechanisms with a clear mandate to protect human rights. Until recently, the ECOWAS, for example, had a regional system, or regional court of justice, but it's not. It is a regional court, but even though we are mentioned the human rights aspects, if we do not have such an organ with clear mandate and protecting the human rights, the challenge will be the same. So these are some thoughts that I wanted to share. Thank you. Thank you very much, Bamba. I think this is very important to highlight this aspect. Sorry. Okay, Musa is asking for the floor. Okay, Musa, go ahead. Thank you. Thank you very much. So Musa from Senegal. Yes, I'm very happy that to listen also people involved in the protection of human rights, civil society organizations. And can you please present yourself, Musa? Yes. So my name is Musa Mbeye, and I'm based in French-speaking Africa, and it's very interesting to listen to the different voices I haven't heard for such a long time. I'm very happy that each of us are participating actively in regards to the respect of human rights. So it would be very useful for us, for French-speaking Africa, to set up different organs. We need to have more information dissemination, but also we need to sensitize the different communities, and not only to relaunch the economies, but also to work on human rights. Our main objectives, the main objectives of our states is to look for investments, but we need also to look at how these investments do have also other consequences for our states. It is also something that I wanted to add for different voices. Instead of looking at different institutions, we need also as organization, we need to work on revising the different laws, human rights laws that we need to protect, and also work for reparations and encourage investments in the right way. So it is very important to add this dimension of sensitizing of organization of human rights. Thank you, Musa. This is very important, knowing the different laws, sensitizing the different public, and also linking this with the different economic activities. And in this kind of the prevention aspect is also very important to underline. So thank you for joining us from Senegal. I hope you are well.
Kidibone, please.
Yes, good afternoon, everyone. My name is Kidibone Sulwani. I'm from the University of Pretoria under the TILA program. I also just wanted to comment. I think one of the previous speakers mentioned it with the issue of integration. I think the main issue here, why most of the time the human rights are being compromised when it comes to investment issues is the issue of competition with amongst the African states. So I think if we can be able to reach a common ground, starting at a regional level, of course, and then going on a continental level to reach a common ground, have a common rule governing how investors should behave when they come into the African continent, then I think we'll be going somewhere, as opposed to now one country having to compromise because knowing that their neighbor country is they have like flexible rules when it comes to human rights. They're not so strict, and that I think makes it very hard for one country to go into the negotiating room with strict rules regarding human rights violations. So I think the main issue is competition. So if we can reach a common ground in terms of how foreign investors behave when they come into Africa, then I think we'll be going somewhere instead of competing. Because I think if an investor knows that in South Africa they're very strict with child labor, however in Zimbabwe we can get away with it, then I think that will make it difficult for South Africa to go into negotiating room with effectiveness when it comes to protecting children's rights and everything. So I think we can be able to, we can try. If we can do it with trade issues, then I think we can also do it with investment issues, and then I think we'll see some progress.
Thank you, Kedibone. Thank you very much. You are highlighting here the need for a more continental regime, a more unique regime to govern all these issues instead of going alone. So yes, I think I had seen an hand before, but I don't see it anymore. So I think we are just managing quite well our time. We are only 5 minutes late. So we were supposed to take a break for about yeah, 15 minutes. So I don't know, I think, no, the break was, yeah, we are a bit late because the break was supposed to be longer, but now we are supposed to start at 3:30. So ideally we would have 30 minutes of break. I don't know if that's okay, or if most of us feel like we should just take a short break of maximum 15 minutes and just stretch our legs and come back so that we can maybe go fast and be able to conclude the second part of our consultation. I am suggesting, if there is no major objection, that we take a 15 minutes break and come back for the rest of the session. I hope that's fine. Okay, I can't hear any objection. Then I consider that's okay. So we will resume in 15 minutes. Thank you very much.
Yeter sabu yer koi, yeter sabu yer koi, yeter sabu yer koi, bangu boyer kamba, Isabel bangu gerga, yeter sabu yer koi. Yeter sabu yer koi, yeter sabu yer koi, bangu ger kamba, Isabel bangu gerga, yeter sabu yer koi, halabori, halabori.
Thank you very much. I hope you have all had a few moments of break, and I guess that we can resume now our today's conversation. We have the second half of the consultation to go now. The first thing we will do is to discuss the third topic and to hear from the last speaker. And after that, we will open the discussions around that topic. And the fourth topic would be, as I said before, more of, conclusion or concluding, concluding remarks and specific demands that we want to make to the working group. J'espère qu'on peut reprendre et que tout le monde est de nouveau là.
I hope everybody is back and we can resume.
On the international investment agreements, the international dispute settlement mechanisms, and the access to justice for right holders. And to reflect on that topic, we are pleased to have Professor Elvis Mbembe. Professor Elvis Mbembe is an associate professor at the University of Rwanda in Kigali, and is also the president of Initiative for Peace and Human Rights, which is an international NGO present in a few countries in the Great Lake region. So I hope Professor Mbembe is with us. Thank you very much, Prof. Mbembe, for joining us today and for sharing with us your reflections on that very important issue. Thank you. You have the floor.
Thank you very much, Benjamin. Thank you, everyone. Good afternoon. As mentioned by Benjamin, I'm talking from Kigali. And for those of you who are following the news, you know that the eastern part of Congo, especially Goma, was recently hit by a volcanic eruption. And currently we are living under repetitive earthquakes. So it is under these conditions that I'm talking to you. Of course, in Kigali, we are not really feeling it much, but just a way of, for those of you who are believers and prayers, if you can put the population of Goma and Gisenyi in your prayers, that will be helpful. Again, I would like to thank my predecessors who have introduced the topic. The advantage of speaking almost the last is that most of the aspects have already been covered by my predecessors, because in different interventions, some aspects related to access to justice were also talked about, which means that I'll do my best to summarize what I was requested to share with you. Of course, I'll do my best to stick to the 10 minutes that have been allocated to me. And one thing that I have to mention here, of course, as we all know, I've also noticed that from different interventions that have taken place previously, we know that this is a very broad topic. When we are talking about international investment, it is a very, very broad, and we cannot just like summarize everything in 10 minutes. So for that reason, I will only stick to what I think like the main thing I'm supposed to talk about. I did not prepare a PowerPoint, but I just made an outline of what I'll share with you. And I have like 4 main points to talk about. The first one is the introduction. The second one, I will highlight the issue related to foreign investment and access to justice. Then I will raise some reflection questions that we can help us brainstorm, but also guide our interventions after my reflection. And fourth, I will talk about a couple of things I think relevant for us to take into consideration as we are sharing our observations. So to talk about this topic, which is very interesting, as mentioned when Benjamin was talking about my background, I've been very close to this academically as a person who teaches international investment law, but also professionally through Initiative for Peace and Human Rights, where we try our best to provide legal aid services, free legal aid services to different people. But what are we talking about when we discuss investment, human rights issues, and access to justice? It is very important for us first to talk about investment regime, because we are talking about international investment agreement. We are talking about the states, the investor-state dispute settlement. So when we are talking about all of this regime, we should think about almost 3,500 investment treaties including bilateral investment treaties between countries and free trade agreements that contain investment chapters. And this we find that in many free trade agreements, specifically regional integration agreement. When we talk about investment regime, we are also talking about a one-way protection system where foreign investors are given all the protection and the states are actually coming like beggars. And in the end, when conflict arises, either because it is a conflict that has arisen between the state and the investor because the investor has been polluting the soil of a river or not, but whatever happens here, most of the provisions in this kind of agreement are actually to protect investors. And for those of you who have done some readings about the ICSID, for instance, when you consider the cases before ICSID, you find that generally, I think for more than 90%, states have been actually condemned to pay damages to investors. So this also shows how this is a one-way system that we are talking about. Another thing that we have to talk about as we're talking about this investment regime is that states' obligations are enforced by means of investor-state arbitration. So I'll come back to this later as I'll be talking about the main issue that we are facing here. As we are talking about the access to justice, about conflict that may arise between the host state and investor, we should roughly think about more than 800 known treaty-based investor-state claims. And most of those claims are actually to challenge the state decisions, the state policies, measures of public interest, whether the state has put in place or would like to enforce some provisions related to the protection of environment, or if the state would like to stand for the rights of their citizens, or whatever happens. So these are the kind of issues that happens. But on the other hand, now we are having the issue related to access to justice. This is an issue that has received very little attention over the years. The problem is that victims face legal and practical barriers to accessing justice and obtain effective remedies. And here I'm actually highlighting the effectiveness of the remedy, because having access to a remedy is one thing, having the remedy as effective is another thing. So in many initiatives have been taken. For instance, in 2014, the UN High Commissioner for Human Rights launched its accountability and remedy project to seek solutions to overcome obstacles undermining the effectiveness of judicial mechanism in achieving corporate accountability and access to remedy on the context of business-related human rights abuses. So this project led to the publication of guidance for states on improving judicial mechanism at domestic level. Again, I have to highlight here the fact that it was actually to find how we can enforce, we can improve judicial mechanism at domestic level, because in other interventions that we had previously, I think we had some kind of recommendations that justice should be sought first at the domestic level. So there are also already some initiatives in that direction. Also, addressing barriers to accountability and effective remedy for business-related human rights abuses has also been central to discussions on international legally binding instruments to regulate the activities of transnational corporations and business enterprises with respect to human rights. But how does this interact with the African context? That's why for me it is important now to talk a little bit about what I think about the African context. Of course, when we're talking about investment and we want to, in the context of African context, we think about resources, natural resources, because most of the investors who come to Africa because of the resources that we have as a continent. So this is one thing that we have to consider, that we have, I cannot say unlimited resources, but Africa is endowed with many resources. But paradoxically, we are having African countries, we know that most of our countries are poor. And as poor countries, we were told at a certain point that we need foreign investors to come boost our economies because they bring capitals, they come create jobs, they come also with new technologies. And it is said that in the long run, these people would help our economies to grow. Because we consider investors as those people who will come to do us good things, they are considered as saviors for most of African countries. And because they're considered as saviors, our governments feel the necessity, a kind of necessity to overprotect, because I cannot just talk about to protect. It is a kind of overprotection of investors. And we talk about overprotection because on the other hand, we are having the people, the citizens, the populations who are not actually given due attention, especially when their rights are violated by those very investors. Another thing that we have to consider, which is a corollary with what I've just mentioned, is that most of African countries, when we look at good governance index, we find that most of African countries are ranked at the bottom. When we consider rule of law index and indicators, we find that most of African countries are not well ranked. Our judiciary is considered as corrupt. So against all these backgrounds, we are having a situation whereby domestic justice is compromised. And here I'm trying to also address one of the questions raised by Mr. Nelson. So we can think about our domestic system, but against all this background, do we think that we are having a system that guarantees the foreign investor that if they go to our ports, they will obtain justice? Of course, this is not the point that we should care about more as we are discussing here. But this is also something because when I read the concept note of the activity, and as rightly mentioned by one of my predecessors, I think the lady from UNDP, it is also about how to strike a balance between the right of investors, how to make investors feel comfortable when at the same time we are also protecting the right of our citizens, the right for them to get access to justice. So as we are thinking about this, we should also have a look, an internal look, an intrinsic look to our own affairs to see whether, if we consider our system as they are currently, if it's really create that trust, that confidence in investors. But we cannot talk about the African context without mentioning the fact that in most of African countries, we have the issue where governments do not want to let citizens participate in starting from the negotiations of investment treaties. And even when there is a dispute, it is because you already didn't participate in the negotiations, you don't even know whether the investment treaty contains any provision granting you some right to seek reparation or redress. So this actually blurs all the system from a citizen perspective, that the involvement of the citizen in justice seeking becomes even jeopardized. It becomes very difficult. So this is what I have to draw as the general African context against which we have now to assess the issue I'm raising here. So against all this background, we find that the main issue that we are talking about when we are talking about investment and human rights and access to justice specifically, it is that most of investment treaties do provide for international arbitration as a means of conflict resolution. And most of those mechanisms that they put in place are actually set in a way that citizens do not have a direct place for them to come and express their concerns and obtain redress. Actually, when you look at even the names, when you consider like ICSID, you find that it is something related to states and nationals of other countries. And when we talk about nationals of other countries, here they are considering investors. And when we even talk about the investor-state dispute settlement, as mentioned in the title of this session, you already see that the place of the citizen, the place of individuals, the place of communities is not there. It is about state and investor, a foreign investor. So this is the system that we are having. Within this system, we are now having a kind of justice which usually sits remotely. I mean, here it could be something that is happening. Let's talk about the conflict. Suppose that we are talking about a conflict related to Kibali mining in Ituri in Eastern DRC that is polluting the waters of Shari River. And the direct victims of this pollution are the people living and around this river. But when a conflict arises where the state has to respond, this conflict, if it sits, if the tribunal, the arbitration tribunal, if it sits in a near place, it will be probably in Kinshasa. But usually it is London, it is Paris, it is New York. So this mechanism is built in a way that it is very remote, whether it is ad hoc or whether it is through permanent courts like the ICSID that we are talking. But that is not itself a problem. Apart from that remoteness, we find that there are also a number of issues that exclude individuals and communities from their meaningful participation in the process. We have, for instance, the issue of language. When you look at, you follow most of these arbitration proceedings, leave alone the investment treaties, they are drafted in English. And for someone who lives in Ituri, where they speak their local language, they don't even have that possibility, leave alone Congo as a country where most of the population speaks French. So the language in which the treaties are drafted, the language in which, in case of conflict, the proceedings are conducted are usually, is usually a foreign language that is not easily accessible. Apart from that, the proceedings also may end up happening, as I previously mentioned, in a foreign country. But here I want to talk about the context. It is very unfriendly because the procedures that are used, the judges who are selected, the arbitrators, who are selected, And whatever happens in a way that actually sounds very unfamiliar to these common people who are actually the right holders, then they cannot participate. Someone before me mentioned the amicus curiae process, but we should know that in international arbitration, this becomes even very complex. I will not enter into these details, but one of the things that makes it even aleatory is that for even a party to be accepted as an amicus, the decision has to be taken by the arbitration court itself, which means that they can even reject. Another challenge with amicus is that when you are going to present a case as an amicus, you want to intervene into a case as an amicus curiae, you have to appear as neutral, because that is the role of amicus, because you are advising the court. But how would you advise the court when you are already a party, a victim to that case? So it even makes the standing of the victim vis-a-vis amicus curiae process in international arbitration very difficult to stand as a possibility. So this is the issue. Against all this issue, what do? We are having this international tribunal. We are having all the problems that we have just mentioned as the problem. So the question here is, how do we ensure that that population living in a remote Ituri can have access to justice? So this is what we are discussing here. For me, we have already talked about many issues. I just want to raise a couple of questions that we may need to consider as we are thinking about, we are reflecting about how to improve this.
Yeah, Prof, if you can do that in a very few minutes and wrap up, that would be great, yeah.
Thank you very much. That is also the plight of a person who is last. Then the minutes are counted. But I'll really try to summarize it. If need be, then I can even send it to Professor Surya, as previously mentioned. One issue, I think, from previous interventions, we were talking about the role that the home country of the investor can play. Is that something that we have to consider? Should the home country play a bigger role? Another thing, as we are talking about transparency, of course, there are already a set of instruments. So what else should we? Should we increase? To which level? Should we increase the obligation of transparency and the participation of the population? But also, to which level should the human rights impact assessment be taken as compulsory? And how can this be monitored? Another question that also came from previous discussions, as we are talking about access to justice, because we have said that the way the investment treaties are built in, they are built in with this international arbitration. So is it now a possibility? Is it something we can consider for African countries to opt out from these mechanisms so that they can make a kind of tabula rasa for them to renegotiate two new investment treaties? They can get inspiration. I heard someone mention the SADC model of BIT, which is considered as one of the best, or the Morocco-Nigeria BIT, which is also inspired from the SADC model of BIT template. Is that something that we have to pull out so that we start the drafting of new instruments that get inspiration from this kind of arrangements? Should the obligation to exhaust, because someone also mentioned this, should we now get treaties where the obligation to exhaust local remedies should be imposed as a condition before investors can resort to investor-state arbitration? Can that help our people? And another thing, which probably I will stop by now before I can talk about others, I think I will leave them out, is now about our local courts. Of course, when I was talking about the African context, I mentioned how our court system might not be credible vis-a-vis the investor. But then what can we do to increase that confidence so that the investor, when they are invited to defend their situation before our court, they can feel confident, they can trust our system? In Rwanda, or at a certain time, they introduced, and I think in many other African countries, for the same reason as the one we are discussing here, they introduced what we call commercial courts. So should we empower, strengthen commercial courts to also start hearing investment issues? Maybe. Or should we simply create now investment courts in our countries? So these are a couple of questions that I think we should consider as we are discussing. But as we are also thinking, I have some points that we have to take into consideration. One is that we have to consider that right holders should be central in any remedy process, because they are the victims. And when we are talking about remedies to the issues they face, then they should be considered as central, not like third parties to whom we only give some avenues like amicus curiae or whatever. We should also think that when we're talking about effective remedy, there are two elements that we have to consider. The process itself must be strong enough to guarantee that the remedy that we'll obtain in the end is good. But again, as I'm talking about the remedy, we have to take care of the outcome. The outcome must be also something that comes to redress. And the last point here, I'm skipping two others because for the sake of time. The other thing that we have to consider as we are talking about the remedy, we should always bear in mind that remedies should be deterrent, preventive, redressive, and can be located in diverse settings. It means that they have to be considered as people who, right holders should be given the possibility to go through litigation. They should be given possibility to opt for alternative dispute resolution. They should be given an option to go before domestic courts or regional courts or even now international courts that exist. So this is in a few words what I thought to share as a reflection, and I will remain around if there's any need for me to clarify or add more. Thank you very much. And thank you for patience, Mr. Benjamin.
Thank you very much, Prof. Mbembe, for the brilliant insight that you have been giving us. It's true that yeah, you were detailed enough, and that's good in a way, because it also permit probably our participant to just come in and comment on the very broad range of issues that you have already mentioned. So I would like now to give the floor to open the floor. Many issues have been touched upon by Professor Mbembe, and I think many of his ideas and reflections are shared by quite a good number of us. So I will just open the floor, and yes, anyone who wants to come in, I will just share the screen for our questions under that particular topic. Let me read them first. In what ways do international investment agreements and international investment state dispute settlement undermine meaningful access to justice for right holders affected by investor state claims and the investment underlying those claims? How could international investment agreements constrain investors' ability to use international investment agreements by bringing unreasonable but maybe permissible claims. How can it be done, and which kind of limits can be put around the claims investors can bring under international investment agreements? What would be the political benefit of these limits, including in terms of reassuring investors? That's something Prof. Mbembe noticed. What other reform solutions could address the impact of investment on human rights and the environment? So the floor is open, the floor is yours. Please feel free to come in. Yeah. Anyone? Oh, Prof. Mbembe has said it all. I don't know if on your side, Prof. Suraya, you want to make any comment at this particular point in the discussions. You're welcome to do that.
Thank you. I think I'll be, of course, more interested to hear what participants have to say. And I think access to remedy is a critical component, and I hope that the report can highlight this issue. One key question, of course, is that whenever investors say that the legal system in a country in the global south is not sound enough, it is not good enough, that's why we need ISDS, we need an arbitration system. They make this argument. But at the same time, when the communities would like to bring the claim against them, let us say in Europe, they will always say, oh, go back to your own country, because that is where you should seek justice. So I see this paradoxical. I don't know if participants have any comments on this issue of access to justice, because investors are not taking a consistent stand. The other issue in which I'm quite interested is how to build political will. Some of you talked about states should do ABC when they are negotiating those investment agreements. Sometimes they act in compartments, sometimes they are competing for investment. How to stop all this? What are the steps that can be taken to build a political will, a collective will in the states in Africa, that okay, all of us will stand together. These are our basic standards, and whoever wants to invest, they're most welcome, but these are non-negotiable. Is that feasible? Is that possible? And how to achieve it? Thank you.
Thank you very much, Prof. And yeah, this add on to the conversation, onto the reflections that Prof. Mbembe already had. Joyce, you have the floor.
Thank you.
And after you, yeah.
Sorry?
And after you, Nelson. Thank you.
Okay. Thank you so much for this opportunity once again. I just wanted to perhaps respond to the first question that says, in what ways do international investment agreements and ISDS undermine meaningful access to justice for right holders affected by investor state claims and the investments underlying those claims? I'm just going to highlight a few issues that I think the ISDS undermine, access to justice. And to begin with is to say that in most bilateral investment treaties, you find that states are not able to institute claims as claimants. They are mostly respondents in the ISDS mechanisms, which is based on how the arbitration clause is is drafted in the BIT. So just the fact that investors are the ones who have in most cases direct access to institute claims for violation of their rights is an issue in terms of states not being able to institute claims on behalf of victims, in the sense that they want to represent, they have the obligation, the human rights obligation for its citizens. And also the fact that the other option, which is also not as common, is the ability of host states to institute counterclaims. Yes, we have seen a number of exit cases where there have been counterclaims, but it is not enough, and it is not always that counterclaims are allowed under BITs. And then just the fact that we have communities not having direct access to the ISDS mechanism is also an issue, and I think the previous speaker has highlighted the same. Given that they're the direct victims of a lot of human rights violations, yet they don't have access to the ISDS as it should be, and there has been also a perception about arbitrators within the ISDS being pro-investors. It perhaps is a legitimate perception, given the different awards, the inconsistent awards that have been issued in that sense. Yes, there have been cases like the Ubaser case, the Bywater case, the Tanzania Bywater case, among others, where we see that arbitrators are taking advantage of broad jurisdiction clause and arbitration clauses to have jurisdiction over matters that have to do with human rights. But it is also not common enough. So the ISDS mechanism has been undermining the ability of communities to access the platform in that sense. And the fact that arbitrators have been given arbitral tribunals have been given so much power in terms of giving awards that have a direct impact on national policy, even issues to do with public health, environmental protection and taxation. And the fact that foreign investors are able to challenge public action by directly accessing the ISDS system, as opposed to also now the victims of human rights violation having a similar opportunity. So there needs to be a balance in terms of the rights of a foreign investor and the rights of communities. And I think the perception that national courts are not there's that perception of bias. It's not always the case, because in some jurisdictions, and I want to give an example of Kenya, for example, we have quite some robust laws, and our judiciary is also issuing jurisprudence in this particular issue when it comes to like environmental impact assessments and those kind of issues. And I think it's a perception that should change, because from a national point of view, I think it's particular countries to look at their particular frameworks and laws and ensure that they're actually meeting their human rights obligation. But it's not always the case that all countries don't have the institutional or national judicial systems to provide for communities. So I think it should be looked at from a national, each country perspective, because countries are the fact that countries are at different places in terms of the institutions they have. And so and finally, I'd like to suggest that perhaps dispute prevention methods and exhaustion of local remedies should still be prioritized in terms of an alternative to ISDS, and participation of local communities also to be given a lot of concern in terms of how the ISDS system has been, and for all these years. So yeah, thank you.
Thank you very much, Joyce, for your contribution to that issue. Thanks a lot. Nelson. Yeah, please go ahead, Nelson.
Thank you, Dr. Traore, for this opportunity once again. I just want to say, with respect to the ISD system for resolving investor state disputes, I think that the system as it is now, right now, cannot in any way guarantee or enforce human rights violations in investment activities. And I say this because I come from a dispute resolution background, right? Wherein I have done some litigation and arbitration matters, and I can say this for a fact that I do not think that the way the system for resolving these disputes is set up now, which is by arbitration, right, is conceptually good enough or sufficient to address human rights concerns. I'll give an instance, right from the persons who are appointed as arbitrators, right, in these referrals, in these investment dispute referrals. How many of them have the human rights or human rights law and practice backgrounds? How many of them? The truth is that you see most of them coming from investment and commercial law practice background. So you really can't expect them to appreciate, you know, human rights issues that have arisen from investment activities and then expect them to give it a just determination. It's not possible. So I do not even think that the way the system is shaped now as arbitration per se is enough or is competent enough, yes, to address the issue of human rights violations. So I think we need to reimagine the entire process going forward. And I would also like highlight on the need for giving local standard to, you know, communities, local communities. We can argue that the fact that states are usually limited in bringing counterclaims, and in fact bringing claims, engaging claims against against foreign investors is a problem in solving human rights violations in investment disputes. But the truth is, how many states would actually go out of their way, right, to properly ventilate human rights violation claims of local communities? I mean, let's be practical here. You see that the role of the state, usually the primary role of the state in getting this foreign investment, is to get as much foreign investment as possible and to create a very facilitative environment for this foreign investment to thrive and for more foreign investors to come. So you would not really expect them to be able to push human rights violations suffered by the average man, the average local man in the local communities as a result of the foreign investment activities of these investors. I do not think they have. I do not think they would be in the best position to do that. It is only these local communities themselves that can actually properly ventilate their claims before investment state dispute resolution platforms. Then I think.
Yeah, you are freezing a bit, Nelson. I don't know if you were wrapping up.
Yeah, can you hear me now?
Yes, please.
Yeah. So I also think Professor Sawyer Deva raised the issue of, you know, how we can gather as much political will as possible for, you know, African countries to come together and ensure human rights protection in foreign investment. And I think this is where we should bring in the AU, right? The fact that we do not have any supranational body in Africa has been a problem, yes. But I think the AU can stand in this process. We can have a protocol wherein, or we can have a situation wherein the AU adopts, you know, an investment protocol that is targeted at ensuring and protecting human rights in investment in Africa, right? And not just intra-African investment, but also extra-African investment, foreign investment coming into Africa from outside Africa. I think it would be a very, very compelling platform, for countries to be able to, for African countries to be able to come together and agree on it. So those are my thoughts.
Thank you. Thank you very much, Nelson. This is very helpful. I can see that Prof. Soraya has raised his hand. I encourage other participants also to voice their thoughts and their concerns. I know that this topic is has a lot of intricacies and technicalities. It's not always easy to go through these technicalities, but I would like to hear also from other participants. That would be great. We still have a few minutes to go under this topic. I will now give the floor to Professor Soraya. I can see Bamba and Adetutu. So Professor, please go ahead.
Thank you. I think Nelson raised some important points about ISDS, and in our different consultations, we heard different voices. Some people saying that ISDS can be reformed. Some people saying it cannot be reformed. We must dismantle it completely. It cannot be reformed in a balanced manner. So I'm just curious, what is the view of participants from Africa? Do we completely dismiss ISDS system, or can we reform it in a radical manner to ensure that there is some kind of a balance?
Thank you, Prof.
Or could there be a permanent court of arbitration that can be used? Because there are different ideas being floated. Thank you.
Thank you very much, Prof. Yeah, I guess Nelson has raised a very radical position, saying that it cannot be reformed. And yeah, it would be good to hear from other participants. Bamba, je vois que Bamba demande la parole. Je saisis l'opportunité.
I see that Bamba wants to take the floor, and I would like to encourage French-speaking participants to also take the floor and share their comments with us. Although this could be a very technical issue, please do not hesitate to take the floor. Bamba, you have the floor. Thank you very much, Dr. Benjamin.
Thank you. I would like to ask a question, but I will also have a concern. So my question is in regards of what are we supposed to do, or what shall we do? So I wanted to know
ne peuvent pas être des remparts.
Can we have the contributions cannot be useful for the communities?
Le protocole de la SLECAF.
As it has been said by the protocol of the it is the notion of the balance that we have been talking about. When it comes to the settlements, when it comes to the international investments, there is what I call something which is unusual. It is about how we can settle the different conflict resolutions. This has been set up with the help of the World Bank, and our states. They have the illusion to go and negotiate and in the different institutions with the different investors. You can be curious enough to see the different results after this processes, after the complaints has been submitted by the different states against the investors, against some businesses, and and you can look at the verdicts. So we are in an international context with a different kind of arbitrations, and these arbitrations are not in favor of our states. We do have more than 136 states which are members, and these members have linked up themselves, and they really believe in their national jurisdictions. I think it's a main concern that we need to look on. Thank you. Thank you very much, Bamba. I'm going to give the floor. I can see you have raised your hand, Abwa. So you have the floor. Thank you very much. It is true that the question of in regards to the reform is very interesting. I think the Professor Surya was asking if we have to reform, what are the alternatives? And I wanted to say that we need to have a reform of the system, but the idea is not to replace a system which has difficulties by another system. We can have different approaches. For example, at the European level, the European states, they're settling their dispute at the European Union level. They have a system which is strong enough. For the African continent, I don't think that we do have a regional system which is powerful. Even at the ECOWAS, at the SADC level, the citizens do not have access to these courts. So it's true that the system has challenges, but I think we need to have more responsibilities on the different states. The states need to respect all actions. It is important to add another dimension, which is a national or a local dimension. The states should be able to address or to modify some aspects before going to the court of arbitration. So 1/3 of the cases were resolved under this procedure. This procedure is used as another way which couldn't be negotiated otherwise. So this has been resolved during this process. So we could have resolved it maybe at the national level. So we need to look at the local remedies before going to the international level. So some agreements might be lasting for more than 6 months, and when it's not always practical. But we need to have something which is alternative. We need to work on the reforms. Of course, the current reforms are very interesting. We'd have challenges, for example, at even the United Nations level. So we are not very well familiarized with the different systems. So in which extent that a consultation system should be applied at the United Nations level, and how can we help the states to resolve some issues? So these are some reflections that I had. I wanted to add to the discussions. Thank you for the opportunity.
I'm told that yes, someone has tried to raise his hand. Abu, I will come to you soon. Very sorry because your hand is not showing up here. Adetutu and then Abu. Adetutu, we will try to be very brief and wrap up here because yeah, we are running after time. Please go ahead.
Good afternoon, everyone. Thank you, Dr. Benjamin. My name is Adetutu Talabi, and I'm also a student of the TILA program. I would like to address the third question, which talks about the other reform solutions that could address the impacts of investments on human rights and the environment. I would like to say that just as we have talked about renegotiating these BITs, in renegotiating the BITs and other IIA agreements, it is important that we put clauses such as the supremacy clause. And that simply means that we are saying that investment protections cannot outweigh social and human rights issues. Human rights issues should be at the front burners, because we've seen instances where these investors have used stabilization clauses against the governments, because the governments are not allowed to change legislation that affects, their citizens. So it's important that we now state that human rights obligations and issues should be priority for government, and investment protections cannot outweigh human rights, social and economic issues. And also on the issue of expertise that we have talked about, we are certain that there are not enough experts in Africa, in those negotiation rooms. The TILA program is an example of a great initiative that is helping to build capacity in that area. And so if we can have such trainings for people in the ministries, for example, bar associations, just educating lawyers and other stakeholders on these issues, it would be easier to tackle the problem of expertise.
Thank you very much, Adetutu. That's a great contribution. Let me now give the floor to Abu, and I apologize because your hand was not up.
Thank you very much. Yeah. So I think a lot of good things have been said. Don't need to
You are breaking up a bit. Can you hear us?
Much.
I don't know if it's on my side, but I think we are struggling to hear.
Can you get?
Yeah, is it my side or anyone else? Yes, I can hear. Yeah, we can hear you now. Yeah, go ahead. Yes.
Sorry. Yeah, quickly, just one point, and that is that investment. If we look at investment and we are looking at investors, we are in the development context of. Now, investments and investors should be placed within the context of the development needs and plans of the particular countries where those investments are based. And if that is to be the case, and therefore the investment is localized, and therefore the development has to be localized. Now, I see no reason whatsoever when the development is taking place in my backyard in Sierra Leone, in Congo, when it has to be taken somewhere else in Europe and America. Principles of human rights that is negated and completely run against. I think it's unacceptable. So development has to be localized, investments is localized, so all processes that should facilitate smooth process that will create possibilities and opportunities for the local people should be localized. There has to be a way to develop instruments and institutions and structures at a local level to ensure that access to justice is sought. And I think the point is that in the initial conception of the businesses, that is where the whole game is lost for the communities. Because in the case of mining, for instance, and agriculture, when it becomes minerals, it's no longer the property of the communities. It's taken as state property. So the communities are put out of the equation. So when there is a crisis, it's like the state, will have to face it. And yet it is the communities that are really having the problems. So I think that if the communities, right from in terms of mining, and I've always made my arguments in Sierra Leone, that let the communities be co-owners of the minerals. If they are co-owners of the minerals, they then become obvious to be consulted properly. So the whole concept of FPIC becomes real, because the state will not just come and bulldoze away the communities properly with the communities. And I think this is where we miss the whole boat. And so if we go back to the drawing board, we recognize the presence and the ownership of communities to the minerals and the natural resources, then there's a whole concept of consortiums really a sine qua non for all businesses. And then institutions and structures to be able to facilitate the running of that business will then become something that can be negotiated properly. That's just what I wanted to say.
Thank you. That's very a key point. That's very important. Thank you for your contribution, Abu. Now I don't see any other end up here. I would suggest that it's true that there was a few there was some questions asked, but I think there were more of also comments. And since this is a continuing conversation and notes have been taken, yeah, I think we will also put them in the whole reflection. So I would suggest that we leave it here for this topic 3, unless someone wants to add something very important. I would suggest that now we move on to the last topic of our day, topic 4, which would be more of a wrap-up session. We will just go straight to the key point that we have identified during this conversation, and we want to put them as a demand to the UN Working Group. I will share my screen. So this topic is titled Contribution from the Working Group's 2021 report. So what are we expecting from that report to the General Assembly of the United Nations? Yeah, I don't have to present or to introduce the General Assembly to anyone here. We know that our states are represented there. So this is a forum where states are represented, including ours. What do we want this report to make as key points from that discussion? So that's the whole idea of this next topic. And I will share my screen so that, again, we can see the questions, the 2 questions. And after that, we will just have some concluding remarks. So the first question here is, what do you consider to be priority issue areas for alignment of international investment agreements with international human rights law that needs to be achieved? In what ways could the UN Working Group's report best support your work, or our opinions and positions on this important issue? So again, I will encourage as much as you can, please, as many as people we can have to just give their thoughts and maybe just make their point very briefly, because now we are looking at very key points that we want to take away from this discussion, but also to put out there before the working group in the process of writing the report. So please, the floor is yours. I recall that Prof. Mbembe wanted when wrapping up his presentation to make a few key points, and he had to stop at some point. I don't know if Prof. Mbembe is still here and want very briefly, very quickly to make these points, or yeah, to share his thought on what we need to put here as a demand to the working group. Okay, I'm not too sure if Prof. Mbembe is audible or is still with us. So the floor is open. Anyone? Abu, are you?
Yeah. You know, I think that the UN is present everywhere. We have the UN systems here. We have the UNDP here. We have the UNFAO. We have so there are various UN institutions, and they have a coordination mechanism. And clearly speaking, they are very powerful because they link directly with our governments and they advise our government, and they also support a lot of the initiatives that the government is undertaking. In fact, the government plans are usually, a lot of it, the development of the plans are supported by government. And they have also mechanisms, for instance, the peace building, processes, human rights. So they support all of those things. Now, the question is, what stops them from prioritizing human rights into businesses? Because they know that businesses are the tool that the governments use, to generate funds and to also, use the funds to do development. But then it is never considered to be so strong that it can actually create this protection and promotion of human rights or the people's rights.
I'm sorry, Abu, we are struggling.
So I think that the UN country level should begin, as one of the key development. I don't know now what I can do. Maybe my internet is getting weaker and weaker by the second.
Better here, but if you can just wrap up, probably, yeah, just give your final thought.
No, I'm just saying that in our countries, all our countries have UN systems, and they are organized and are coordinated. And I think that these coordinated UN systems can actually prioritize business, and business to be infused with human rights, and human rights in all the dimensions, because then there's the protection, the promotion, and the remedy, and then that business becomes the instrument to engage our governments to make sure that it is sanitized. That means that institutions and structures are on the ground, are really strengthened and supported and made to function, and that international institutions are, become really just a great empowerment to the ground. I think this is what I wanted to say, in a sense.
Thank you very much, Abu. Thanks a lot. Yes, anyone else, please? Nelson.
Yeah, and to be a party issue for the alignment of international investment agreements and international human rights law is particularly where the UN can come in, is to propose an institution, right? A judicial institution of the UN, right? That would look into human rights violation arising from investments, Right? I'm not talking about an administrative body like the treaty bodies, the human rights treaty bodies that UN has, right? They've been doing good work, yes, but they cannot substitute or replace a court that would make judicial binding decisions on issues of human rights violations in international investment. So I think we, or what the UN can do, is to propose, first of all, a negotiation as to how we can get this institution, this court, this world court, so to say, for human rights, as it were, to be able to have a global framework wherein people or local communities, state governments, even NGOs, right, and other non-state parties can instigate or ventilate human rights violation cases in both investment activities and all other activities on a global platform. So I think for me, I think that is a key issue, a priority issue that the UN can push through or work towards. Thank you.
Thank you, Nelson. SEATINI, Rogers, I guess.
Thank you, Benjamin. To me, one of the key issues that the report needs to capture is the issue of citizen participation into IIA's negotiations. I think it is very important for the citizens and communities to be a part of these negotiations. And also the other issue is a follow-up on the previous suggestions, what has been done, what has been achieved. I think we also need to really understand how far we have gone. Thank you.
Okay, thank you very much. Is there anyone who would like to come in? I can't see anyone. I would just say that, okay, Joyce.
Thank you. I'm just going to give a very brief priority issue that I think should be, the focus of the working group. I think the UNCTAD has been working on the issue of reforming, the investment treaty, the BITs as they exist. And I think that is a very priority area because even the ISDS emanates from these bilateral investment treaties. And we can see the issue is actually emanating from the substance and the systemic issues that are within the substantive laws, So for me, I think a priority issue, and at least even for African countries, is now practically implementing, trying to modernize investment agreements in a way that they capture the issue of sustainable development and protection of human rights. And I think for a lot of African countries, there is need for technical expertise and in terms of even, literacy levels and assisting in, participation of communities to understand and to have a place in the process of the negotiations of these treaties. And I know perhaps it might be a long shot for the UN because at the end of the day there need to be like national laws and regulations that allow for it. But even for countries that have them, there's a challenge in terms of the capacity that we have as African countries. The issue of literacy, the issue of lack of expertise, which I think now the UN can come in quite handy to assist, to work together with NGOs and CSOs and even the communities themselves, so that even if we achieve public participation to some extent, it is actually meaningful because the communities actually understand what is happening and their inputs can actually make a difference in terms of the investment law regime. So for me, I think the priority issue is modernizing and reviewing these bilateral investment treaties so that they provide for sustainable development and human rights protection. And yeah, so I think that is what can be a priority issue in my in my opinion, because this ISDS system is emanating from these bilateral investment treaties. If we want alternative mechanisms, they also need to be provided for in the substantive law. So if they do not exist and if the review is not done, and we also need to acknowledge the fact that a lot of these BITs have very stringent provisions that with regards to termination of bilateral investment treaties and review, where you find that countries are withheld, or there's like a duration of time with which investors are protected, in the sense that termination is quite difficult. So perhaps a review and moving forward, as states negotiate more in IIAs, they should actually factor human rights and sustainable development, such that countries are inviting, investors who are willing to have responsible conduct within the host state jurisdiction. So basically trying to say that countries should be encouraged, or countries should be open to allowing foreign investors that are actually going to respect and protect human rights, because this grand bargain that African countries are gaining so much from foreign investment, at some point is actually difficult to substantiate, especially because it's not always the case that this foreign investment actually create employment or advance development in our countries. So that, I think that is an area of priority, reforming these IAAs.
Thank you. Thank you very much, Joyce, for your contribution. Very important points. I can't see any other end. I think, okay.
Doc, just a quick one.
Yes, please, Jack.
Before we conclude, the very specific organization that is dealing with these issues that are relevant here, you have the guiding principles on business and human rights. And from one of the presenters, we realized that we are having a soft reaction in terms of soft law. So if you could maybe push for these principles to be actually hard law in terms of a treaty on the same, for our states to basically be members to this treaty. It will have obligations on states in Africa and any other states in whatsoever jurisdictions that they are in and regions. So that from that, then we can move the conversation into treaty provisions that ought to be respected, as it is the case with other human rights obligations.
Very, very interesting, Jack. Thank you very much. As you may know, the treaty process is going on, and there are many uncertainties, to say the least, around this process. And I hope to see more engagement in that process by African countries, which is not the case. ACCA is especially involved in that process since the beginning. And when we take stock of all that has been going on, we are concerned about the involvement and the engagement of African countries in that process. But let's hope that this is another front on which we should fight and demand our state to get more interested and involved in that process, and to be at least on the table of negotiations. Sometimes they tend to be more attracted towards investment treaties. That's exactly why we are here, and how we can use that platform, investment treaties and negotiations of investment treaties, to ask our state to push forward for these the concerns that have been raised during that discussion. Before concluding on my side and giving the floor to Prof. Souraya, I can see that Bamba would like to take the floor. Bamba, tu as la parole.
Merci beaucoup, docteur. Juste,
thank you very much, doctor. I just wanted to forward a proposal. I think in the dynamic of this process, we need also to take into account the registration of the results, because this is how we can look at the progress when it comes to the protection of human rights within the different treaties. It is important to know the progress and to have good indicators and the different cases taken into account. Thank you. This is a good point. We need to have indicators, results indicators, how we are going to assess the results within this process, which is taking into account the human rights aspects and the environmental aspects in the different discussions around the investment treaties, but also in the implementation of the latter. I think it is very important.
Just say that the most important issues that are of a big concern of all the participants here have been raised under each topic, and I think there are very clear demands that have been made under each topic that we would like to see reflected in the report. But I'm quite sure that Prof. Soroya has been taking notes, and on our side we have also been taking notes. We will prepare a short report of all the reflecting the main the salient points that have been raised during the discussion. So I would just now like to give I would give the floor to Prof. Soraya for his concluding remarks, and I thank everyone here for staying. I can see that the number has dropped a bit, but it's understandable. It was long, and yes, the virtual fatigue is here, and it's understandable. So I will just give the floor to Soraya, and maybe just after that I will conclude.
Thank you very much, Benjamin, and thank you all the participants for very valuable input on different themes and different issues. This is very much appreciated to hear what are the issues that are of greater importance for states or other actors in Africa. This is very useful. I have made my notes, and let us see how much of this could feed into the report. Some of the issues that you highlighted were also heard in other consultations, but there are also some issues that were a bit different or unique. And I think that is the added value of these regional consultations. So I very much appreciate your active participation and contributions. If anyone would like to provide any written submissions, you still have time. So please email those submissions to us. Otherwise, we would very much welcome a short summary report of the consultation from ACCA, SEATINI, and UNDP. And it has been a long stretch of this consultation, so I will not take too much of time. And I would like to thank once again all the co-organizers for collaborating with us and doing this consultation virtually. In particular, I would also like to thank UNDP for providing financial support for simultaneous English-French interpretation, which was very vital, and without which we could not really have done that. And of course, last but not least, I would like to thank Benjamin for his leadership in coordinating this. Thank you very much. And of course, all of you. So thank you very much once again, and back to you, Benjamin.
Thank you a lot, Professor Soraya, for giving us the opportunity to have this very important and needed conversation. It was our pleasure to be part of the organization together with SEATINI and the UNDP. And I would also like to thank all the participants again. I know it was not easy to stay online for such a long time. It was very appreciated, and your valuable contribution would be mentioned in our report, and we will send that report to the working group. Again, thank you very much. I wish all of you a good afternoon, a good evening, and we will follow up on any important reflection or information around this consultation. Thank you very much again, and all the best.